Hey. The Circuit Court for the County of Iron Cliffs is now in session. You can be seated.
For those of you I haven't met, my name is Weaver. I'm from downstate, and I'm sitting temporarily while your good Judge Maitland is recovering from a severe illness. There's no need, I think, to dwell at length upon my methods. One judge is quite like another. The only differences may be in the state of their digestions or their proclivities for sleeping on the bench. For myself, I can digest pig iron. And while I might appear to doze occasionally, you'll find that I'm easily awakened, particularly if shaken gently by a good lawyer with a nice point of law. We will now take up the criminal docket. Case number 1, the People versus Clarence Madigan, breaking and entering in the nighttime. Will the defendant rise and come forward?
That's me, Your Honor.
State of Michigan, Court of Iron Cliffs. I, Mitchell Lodwick, prosecuting attorney, come into said county of Iron Cliffs and give the court to understand that one Clarence Madigan, alias One-Shot Madigan, alias Smoky Madigan, did break and enter the dwelling house of Casper Katz and did there commit the felony of larceny on said premises.
Does Mr. Madigan have an attorney?
Oh, no. A man's got to have money to ask them fellas the time of day.
Well, Mr. Madigan, if you're impoverished, it's my duty to appoint an attorney on your behalf.
Oh, I wouldn't bother, Your Honor. I stole the whiskey. I'm guilty as hell.
It was a full case of expensive bourbon, Your Honor.
Did you sell this whiskey?
Oh, no. I drank it.
All of it?
You bet, Judge.
Are you aware that it will be necessary to punish you for this crime?
It was worth it, Your Honor.
Well, I'll accept your plea of guilty, Mr. Madigan. You'll be sentenced later. You may now return to your place.
Thanks, Your Honor.
Case number 2, the People versus Frederick Manion. The charge, murder.
Paul Bigler for the defendant. My formal appearance is already on file.
Which of these men is your client, Mr. Bigler?
None of them, Your Honor.
Mr. Sheriff, will you produce the prisoner?
Well, I'm afraid I can't do that, Your Honor.
Perhaps someone should explain. I'm not clairvoyant.
The defendant is in Detroit being examined by a psychiatrist, Your Honor.
Shouldn't the court have been consulted before the defendant was allowed to leave its jurisdiction?
Well, Your Honor, we're dealing with the Army in this matter, and this is the only crack the Army would give us at one of their psychiatrists, and the court was not present, and it was very urgent that we get the defendant to the psychiatrist.
What does the attorney for the people say to this?
It was done with my knowledge, Your Honor.
I've always heard that this upper peninsula of our fair state was a queer place. If it's customary here to allow a man charged with first-degree murder to wander about at will, I don't suppose it behooves an outsider to point out that the law makes no provision for such quaint liberalism.
Your Honor, the defendant is in the care of a deputy and will be returned this afternoon.
We'll formally arraign the defendant on his return. For the sake of the docket, can you give me a clue as to his plea?
The defendant will waive reading of the information and stand mute.
A plea of not guilty will be entered. The case of Frederick Manion will be placed first on the trial docket.
Can you hurry it up, Polly? Somebody tells that judge the prisoner was lounging around the railroad station. He'll really give me the works.
Just take a minute, Sheriff.
Okay.
Thanks. Come on over here. Well, Lieutenant, how'd things turn out?
I was temporarily insane.
Did he tell you that?
Yeah. He said he's going to write you a letter, but I took some notes on my own. Doctor's name is Smith.
Smith? Anatole Ludwig Smith or Ludwig von Smith, I hope. A name like that would impress the jury.
No, just plain Matthew Smith. He said that when I shot Quill, I was suffering from dissociative reaction.
Dissociative reaction. Well, sounds pretty good, doesn't it, Pa?
Yeah, what does it mean in plain English?
Well, it means I had an irresistible impulse to shoot Quill. Well, that's okay, isn't it?
Yeah, but what did he say about your knowing the difference between right and wrong when you shot Quill?
I don't think you said anything. Why? Is that important?
You better not keep the sheriff waiting. You better go.
Thank you, Sheriff.
You ever heard of a Michigan court accepting irresistible impulse as insanity?
No, maybe we better switch to self-defense.
Even Mitch Ludwig would make a monkey out of us on that. Damn strawberry soda.
Here, want a peanut?
No, thanks. Well, tomorrow's Saturday. We just have the weekend before the trial.
When do you want to start working?
Tomorrow morning. Early.
Polly!
Hey, listen to this, Parn.
Never mind that. Just fine. People versus Durfee, 62, Michigan, 486, year 1886.
Yeah, that's it. I have it right here in the ALR. Listen. Listen, the right and wrong test, though condemned as being unscientific, is adhered to by most of the states. But, now listen to this but, the fact that one accused of committing a crime may have been able to comprehend the nature and the consequences of this act and to know that it was wrong. Nevertheless,
Dear, sweet, endearing word, nevertheless.
nevertheless, if he was forced to its execution by an impulse which he was powerless to control, he will be excused from punishment. Why, the Michigan Supreme Court did accept irresistible impulse, Parn. This is precedent. Boy, I think we got a hold of something here. Good old Durfee, 1886. How about that? Give me a pad.
By the saints, this strawberry soda pop is beginning to taste like real bourbon whiskey.
Now, well, don't get drunk yet. You know, we've got to convince a jury that our client was irresistibly impulse. Remember that.